Thank you so much just for having the opportunity to present to you today on elderly negligent care cases. My colleagues, a couple of colleagues in Glasgow and myself have been involved in pursuing these types of cases for the last 5 to 6 years, which is interesting. So I've just through the course of the presentation, what I hope to chat about is why there's been like an increased demand for in elderly negligent care cases. Try and explain just what we mean by negligent care. I'll then look at the common types of negligent care claims that we pursue just in our everyday practice. And I'll also just identify a couple of cases that we can't take on. Then I'll just run through how we actually pursue the claim and actually some of the challenges that we encounter when we are pursuing elderly negligent claims. Then I'll have a chat about what compensation we actually can recover in terms of negligent claims. Then just finally, I just hope to give you just 5 examples of the common types of claim where we have been successful and just explain the circumstances and why we've been successful and the level of compensation that we have managed to recover for the clients. So in terms of why I think there's been so many elderly negligent care cases, is there's certainly been an increase in the past few years since I've been doing this type of work, is that, as you know, our population is ageing and it's predicted to continue to age in the future. And whilst it's lovely that we do have better standards of care and people are living longer, it does mean that as we get older, that people develop more underlying comorbidities, such as like diabetes, dementia. So the demand for care for our elderly people is overwhelming, and in order to try and avoid blocking beds in hospital, we have to look elsewhere for the care for our elderly. And generally, like if the elderly person can't be cared for by their own family, then you're looking for packages of care either by a private provider or by the local authority. Feeling which it's sometimes a very difficult decision when someone can't live in their own home any longer, that they have to be placed in a care home or a nursing home. And whilst there are many excellent nursing homes and excellent care providers, sadly there are many care providers and care homes that are not so good, and this is reflected a lot in care inspectorate reports and the one recent documentary about a care home. And unfortunately, it's due to like a combination of factors, that often leads to like a care home not providing good care, and it tends to be a combination of sometimes poor leadership from the manager, not implementing policies or not ensuring staff receive the appropriate training. Sometimes there's lack of resources, and often people who work in care homes or in care providers are not paid very well, so there's often quite high sickness rates, and that puts a lot of pressure on the people who are left on the floor to try and provide a standard of care for the residents in the care home or the people who are in their own home. So I think these factors tend to cause the negligent care, which often results in the injuries that we see in our practice. So what do we actually mean by negligent care? It is a generic term. It just refers to the harm or injury that either a patient in a hospital, a service user in their own home, or a resident in a care or nursing home they experience some sort of harm or injury, and it's due to the failure to provide a reasonable standard of care by the health provider. Now, the reasonable standard of care that is dictated by policies, and usually for care homes and care providers, they usually rely on policies like the Health and Social Care Standards or guidance from the Care Inspectorate or Scottish Government, and they can create their own policies from there, but that ensures that there should be a reasonable standard of care provided to the elderly people that they're caring for. Within health boards, it's slightly different. They tend to have their own policies, which have come about after best practice groups deciding what should be the standard of care or the minimum standard of care, and they look to Scottish Government and the National Institute for Clinical Excellence to provide guidance on what the standard of care should be. But one thing we always say is that in order to make a personal injury claim, that the elderly person does actually have to have sustained an injury, either physical or psychological. So I wanted just to chat about some common types of negligent care claims that we encounter all the time in our practice. And it'll be no surprise that falls are the highest, they're the most common type of injury in care homes, hospitals, and at home. And falls in care homes, when someone should be supervised, often result in kind of fractures. And another scenario is sometimes in hospitals where like an elderly person should have one-to-one supervision and they're left unattended, perhaps in the bathroom or to walk, and they fall and fracture their hip. The other most common type of falls, it tends to be falls from height, and we sadly we see an awful lot of falls where elderly people are being transferred, either using a hoist or if they're on a bath chair and being hoisted into the bath or out of the bath, and sometimes staff, they don't know how to use the equipment properly, don't attach slings properly, or they don't ensure that the arms of the bath chair are down, so people fall. And I've had quite a few cases like this, and they're falling from at least sometimes a metre in height, falling and hitting their head either on the bottom of the hoist or onto a hard floor, and it often results in serious fractures, but more often it's catastrophic because the elderly person tends to suffer like a bleed in the brain, which is often fatal, and that's really sad and easily avoidable with training. The other types of falls is often if someone should have bed rails up and the bed rails have been left down and they fall out of bed again from height. And another common type is where an elderly person does not have like a core balance and they can't sit upright in a chair, and they're left either in a wheelchair or an inappropriate chair without a lap belt, and they fall forward and hit their head off the floor. Again, that's quite often can lead to kind of catastrophic injuries. In terms of medication errors, again, we see this quite commonly when an elderly person is receiving care in their own home, or if they are a resident in a care home, and it's either that the person has been given the wrong dose of the medication or the wrong medication. And again, the range of injuries can be that they require hospitalised to correct the medication error, or it can lead to death. And one recent case that we've just been instructed in was an elderly lady who was very slight, so she's very thin, and she was due to be given 1 ml of morphine for pain by her carer and 15 mils of another medication for her tummy, and the carer got them mixed up and gave her the 15 mils of morphine and 1 ml of the medication for the tummy, and thankfully she was treated. She was able to go into hospital, had the effects of the morphine reversed, but it can be often catastrophic if people are given a lot of medication that they're not used to taking. Pressure ulcers are basically when the skin starts to break down, and it can either be quite superficial, just the top layers of skin, or the pressure ulcer can extend right down to the bone. Pressure ulcers shouldn't really happen today at all. Like many years ago, I was a nurse before, and when I started out of training, there was lots of pressure ulcers, but there's been so many policies, so much training, and there's been so many developments and equipment to reduce the risk of pressure ulcers. So 95% of pressure ulcers are avoidable. You will always get some people who perhaps get compromised blood supply or maybe diabetic, and they're at more risk of pressure ulcers, but generally speaking, they should be avoidable. In terms of system failures, that tends to happen when the care facility doesn't put policies in place, sort of health and safety policies to protect the safety of their residents. We've had quite a few choking incidents as well. Unfortunately, as we get older, we sometimes develop swallowing difficulties like dysphagia, either due to illness such as strokes or cancers, or there's a narrowing in our esophagus and we can't swallow as well as we could. And sometimes the residents have been assessed by the speech and language therapists who've said that they must have a special diet that's liquid diet, and then inadvertently residents given an inappropriate diet and chokes and quite often dies, like because the food particles get stuck in the esophagus and you can't resuscitate them. So it's really sad. Like these incidents happen, and it tends to be, again, failure to follow policies and procedures and what's in the care plan. The only time where a care facility might not be held responsible is if the elderly resident has got capacity and they choose to risk manage, and that's in their care plan. That would be the only time that we probably wouldn't be able to succeed in that type of case. In terms of failure to secure premises, again, I've had quite a few of these cases where sadly many people with dementia, they don't settle in their care home and they just try to get out, and I've had a few cases where people have managed to get out and have either suffered fractures because they've fallen or subsequently died, like because once they get out they're not dressed for the cold, and they suffer from hypothermia and often die of cardiac problems because of the shock of being out. Sorry, I think the fire alarm's just going to go. Sorry about that. The final type is attacks by other residents. I've only seen a couple of these cases. They can be quite difficult because there needs to be foreseeability. There needs to be a history of the resident attacking other people before and that they should have required supervision in order for us generally to be successful in those cases. So I wanted just to highlight some cases that we probably wouldn't take on. Quite often we have inquiries about just general feelings in care, such as like if someone's perhaps a resident's unkempt or got dirty fingernails or not been fed as much as the relative would like. And generally, we wouldn't take those cases on because they are very difficult and there's no specific injury as such. Infections are another difficult type of case, particularly urinary tract infections and chest infections, because it's difficult often to try and identify the source, and that's what we would have to do. So unless someone has fallen, they've got an open wound, and that there's been failure to dress the wound or seek treatment for it, and then they develop the infection, unless it's a scenario like that, then probably we wouldn't take on cases regarding infections. We did take on some COVID cases initially, but unfortunately we weren't successful because quite often the insurer, the solicitor, would say that they were following the guidance from the Scottish Government, but things may change, like in the future after the outcome of the COVID inquiry. And the final type of kind of falls that we don't tend to take on are where someone has fallen, but there has been measures in place. It's very difficult, particularly in care homes who are stretched with staff, for them to supervise a resident 24 hours a day. 24 hours a day and be there all the time. So if there's been reasonable measures put in place to try and reduce the risk of falls, then sometimes we are not successful in those cases if someone does fall. So in terms of once we have an inquiry about whether we can take a case on, it can be quite, our initial challenge can be, that often we're contacted by a family member as opposed to the injured person. And so it's a wee bit different to like a road traffic accident or an employer's liability case where the injured person is giving you all the facts of the case. Often in elderly negligent care cases, either the injured person does not have capacity or can't articulate what's happened to their family, what's happened to them, or sadly, in many cases, they have died. Often it's an unwitnessed event that may have led to the injury, and sometimes the family who've contacted us, they might not actually have the correct information. So sometimes when we are contacted, we may think it's a really good case at the outset, but sometimes when you start to gather evidence, the evidence changes, and we have to just manage expectations from that point of view. If after speaking to someone initially, we think we're not certain if they've got a case or not, quite often our initial advice is to advise them to make a complaint either directly to the care provider or to the health board, and then we can assess the response. And we also say to them if they want to complain to the care inspectorate that they must do so within 6 months of the complaint. The other thing people often ask is, can they complain about an individual, like member of staff? And they can do, like if it's an individual carer, then they can complain to the Scottish Services Council, or if it's a nurse, to the Nurse and Midwifery Council. And if the health board are not given a good response or an adequate response to, like someone, if a relative's not satisfied with the response that they're receiving from the health board, then they can make a complaint to the Ombudsman. But again, that has to be done usually within about 12 months of the injury occurring. In terms of, like, once someone does have they've received the response letter back, then what we'll do is we'll have a chat with the client again at that stage, and then we'll review the response. And usually, just from our experience, we're able to advise whether we can take the case on or not. And if we are able to take the case on, the next challenge is really just identifying our client and making sure that we know who our client is. Because as I said, that often the people who phone and make the inquiry are not the injured person. So we have to make sure, is the injured person still alive, and do they have capacity? And if they do, then they are our client. And I've been to many care homes where the injured person does have capacity, and I'll speak to the elderly person, and they're often happy for us just to put like a mandate in place so that they get the support of a family member, but ultimately the elderly person would remain the client and have to give instructions, and we would just go out and meet them, like if we had to take certain instructions from them. In some circumstances, sadly, that the injured person doesn't have capacity. So in those circumstances, we just look to see if there's a power of attorney or a guardianship order in place, and then the attorney becomes our client once we've had sight of the appropriate paperwork. In the event, know that if the elderly person doesn't have capacity and there's no power of attorney, then we have to look to have a guardianship order arranged. Now, we would ask a private client solicitor to arrange that for us. We wouldn't have the expertise to do that. But my understanding is that it can be quite timely to have a guardianship order arranged, and costly. So we wouldn't really recommend it in all of the cases if we don't think that there's going to be reasonable prospects of success. So we would just assess the case and advise the relative on that point. The only positive from that point of view, and it's in terms of the Prescription and Limitation Act, the normal 3-year period for personal injury claims would not start until the guardianship order was in place or someone was appointed. Sadly, sometimes, like during the course of our cases, know that some of the injured party either die or they've died before we or as we're taking the case on. So we would just look for the executor, if there's a will, to be appointed as the our client, just in terms of the Section 2 of the Damages Scotland Act. Unfortunately, sometimes, like the injured party has died intestate, they don't have a will. So again, we would seek the services of a private client solicitor to arrange for an executor to be appointed so that we could continue with the case. Okay. So once we've established who our client is and that we're going to proceed with our case, then usually just always at the outset of the case, I always kind of try and manage client expectations from the outset, because there is no automatic right to compensation. And if you don't prove your case, then you're not going to succeed. And as I'd said earlier, sometimes at the start of a case, you think you have an excellent case on paper, but once you start to gather evidence, things change, and it might not be so good, because the facts might not have been correct at the start. So after we put terms of business in place with our compensate funding agreement, then what we tend to do is just intimate the claim straight away, and either an insurer or a solicitor is instructed. And generally speaking, for care homes and care providers, that the case will kind of follow through the compulsory pre-action protocol. And the insurer or the defender solicitor has a period of at least 3 months in which to investigate matters. although in my experience it can take considerably longer for claims to be investigated, just because there's often difficulty accessing records and that. So I often try and manage expectations in terms of how long a case will take. In terms of if an accident's happened in the health board, and we're intimating the claim to the health board, and the central legal office come in, they will not deal with the claim on the compulsory pre-action protocol because it's a clinical negligence claim. So they will just investigate the claim, and then they'll decide whether they either will enter into settlement negotiations or they'll deny liability. In terms of during that period, like the 3-month investigation period, we use that time just to try and gather evidence to support the claim. And the types of evidence that we use are like if someone's had an accident either in their own home or in a care home or nursing home, then we look to and gather the Scottish Ambulance records and the hospital records, and they're often very good at providing a contemporaneous record of what's happened, because quite often the paramedics will speak to staff and say what's happened, so we get a note. We can find out, because sometimes the written records from care homes or care providers are not as good and detailed, so that's why the hospital and ambulance records are good. Death certificates are very useful from the point of view that if we are looking to see if the actual injury that the person has sustained has caused their death, and that might help us with loss of society claims in the future if we can prove medical causation. And we also, on some occasions, there are post-mortem reports, again, which are really useful, and we can recover them from the Procurator Fiscal. In terms of our letter of claim to either the health board or to the care provider, we ask for a whole host of documents. Usually you don't receive these documents till the end of the kind of 3-month investigation period, but we ask for all the care records, risk assessments, care plans, medication charts, their accident reports. We also want to copies of any policies. Like if it's been a fall, we want to recover their falls prevention policy. If it's been a medication error, we want to try and recover their medication policy to see, so that we can then see if staff have followed the policy. We want to recover duty rosters so that we can see if there's adequate staffing for the number of patients in the unit, and we want training records as well. And if it's a hospital, we often ask for the significant adverse event report or local adverse event report, and these are basically incident reports. It's the hospitals decided to do their own investigation into like an injury that someone sustained, and they do a deep investigation. It's a multidisciplinary team investigation, and they reach their own conclusions, and those documents are really helpful to us in assessing whether we'll be successful in the case or not. CCTV footage, unfortunately, we're quite limited in where we'll get CCTV footage from. In most care homes and nursing homes, and certainly hospitals, they don't tend to have that for privacy reasons. However, we do have had a few cases. One was where the elderly person was being cared for at home, and she was supposed to be assisted to mobilise, and the family had installed some CCTV footage, and it was good that they did, because we were able to prove that the carer had left the elderly person as they were walking them through to the living room, and the elderly person fell backwards and hit their head, and they sadly passed away the following day. But that helped us to prove our case. But unfortunately, there's generally not a lot of CCTV footage available. We also ask people to provide us with care inspectorate reports or ombudsman reports. They're often quite useful. I always explain to people that the care inspectorate report, the care inspector will go in and do an investigation, and they'll either uphold a complaint or they won't. Now, if they uphold the complaint, it doesn't translate to that proves your case in law, because sometimes the care inspector are looking at the complaint from a different angle and not really addressing it from the legal perspective. So it doesn't equate that they will win their case on the basis of an upheld complaint. Other documents that are useful are from the Procurator Fiscal, because quite often, particularly if someone has died as a result of an injury, there's an ongoing criminal trial concurrently, and that can run at the same time as a civil trial. And the Procurator Fiscal will carry out their own investigations, including the Health and Safety Executive, and sometimes we can apply to the Procurator Fiscal for documentation. If the criminal trial is ongoing, then they don't like to jeopardise their own case, so quite often we would need to apply by summary application court order to recover the documents from the Procurator Fiscal and the Health and Safety. If we find, at the end of the 3-month period that the care home or care provider's not providing us with any of the documents that we've asked for, we can proceed by way of summary application as well to try and recover the documents, and it puts a bit of pressure on the care home to produce the documents if they have them. And sometimes you'll find that if there's no documentation, you'll get an admission of liability at that stage rather than allow for it to proceed through a summary application procedure. So that can be a useful tool. And in terms of once we've gathered all our documentation, the evidence that we need, we then have to assess, do we have enough evidence to win this case and overcome the legal tests that we need to? And there is a basic premise that anybody who's receiving care, there's a duty of care owed by the care provider, and we just have to establish if that duty of care has been breached. In terms of standards of care, it really depends on where the injured person is being cared for. If they're in a care home, then often the staff are unqualified, generally untrained, therefore the test is whether the standard of care provided to the injured party was reasonable or not. And that's not really for me to dictate if it's been reasonable or not. What I would do is we'll look at the policies to see if they've followed procedure, but if I've got any concerns, then I would ask a nursing liability expert just to comment with reference to the policies if they believe that the standard of care was reasonable or not, and that helps me to prove fault. In terms of a nursing home, they tend to have more qualified staff, so it may be that there may be a mixture of looking at the standard of reasonableness, but also the Hunter versus Hanley standard of clinical negligence may apply as well. And again, this is where we would ask, a nursing liability expert to look at the standard of care provided based on the records and with reference to policies to see, was it a practice that an ordinary competent nurse using ordinary care should have followed? Did they follow that practice, or did they just go off and do their own thing? And we have to ask, would no other ordinary competent nurse have done what this nurse has done in providing the care? And then, so that helps us prove fault. And then we also have to prove, if we overcome the hurdle of negligence, proving that there was fault and the fault did cause the injury, we then have to prove medical causation, which is whether the failures has caused or materially contributed to the injury, and that's when we start to instruct medical experts. If we know that we can overcome the hurdle of negligence, then we'll instruct generally. And for our cases, it tends to be like orthopaedic surgeons or geriatricians. We're looking for them to say, to confirm the nature of the injury, but also we look for them to provide, but for the accident, what the life expectancy might have been, particularly if we're going to try and recover claims for family members. So those are the tests that we have to overcome in our cases. In terms of once we have all the documentation and we've had an assessment of the case ourselves, and if a denial of liability is received and we don't think that we can overcome the legal test, then sadly we do need to close cases. But I always try and do so with some sensitivity, because we have to remember that this is someone's family member who's either been injured or died because of it. Some things went wrong, there's fault, but we just cannot get over the hurdle of the legal test. So we have to close the case, and it is sad, and sometimes family members do become quite annoyed, and it's difficult for them to understand, that there may have been some feelings, but the feelings are maybe just not enough for us to get it across the line and prove in the case and recover compensation for them. So it is difficult for them. If we believe, like having assessed all the documentation, that there is reasonable prospects of success, then we often instruct a nursing liability report to prove fault and just factual causation that the fault has caused the injury. But unfortunately, the nursing liability reports can be very expensive. You're often talking about several £1,000s for these reports. So sometimes we'll ask for a preliminary report in the first instance, just to see if we think, that there may be, if we're right in thinking that there may be fault, before instructing a full report. And then if we have a supportive nursing liability report, that's when we'll instruct our medical causation reports. And then we'll just look to try and negotiate a settlement, either pre-litigation if liability is admitted, or we'll raise court proceedings and try and settle the case. So in terms of what can we actually claim for in elderly negligent care cases, if our injured person is still alive, then obviously we'll look to claim for the pain and suffering that they have endured, and we'll look to use the medical report to help us to value this element of the claim with reference to case law and the judicial studies guidelines. There doesn't tend to be a huge element for services, because most people are in care anyway, so that doesn't tend to be a huge head of claim in elderly negligent care cases. One thing that can be quite a substantial claim is for care home or nursing care home costs, and this is when we have a couple of cases where one example is that an elderly lady had been admitted to hospital. Whilst in hospital, she had a fall which was negligent, and she fractured her femur and she had surgery. But the plan was for her to get home, so she was moved to a rehabilitation unit, where unfortunately she suffered another fall, which was negligent, and she fractured her other hip and her arm. But unfortunately, after those fractures and surgery, she was deemed that it was no longer suitable for her to get back home to her own house. So she required care to be admitted to a care home. So in that instance, we look to our geriatrician or to get a care report to say, well, but for this accident, when would this lady have required to go into a care home? And that's how we can quantify the amount of care home costs that we can recover. In the cases where someone has passed away, then often we're looking for transmissible solatium, the pain and suffering for the person who's passed away, and also we try and recover funeral expenses. In terms of Section 4 of the Damages Act, we'll always try and look for loss of support and loss of society for family members, including surviving spouses, siblings, children and grandchildren. I've not come across this too often in many of my cases, just because the elderly injured person who's perhaps passed away were widowed anyway, so quite often we don't have to look for to claim for personal services or loss of financial support in terms of pension, but these are things that we have to be aware of when we're dealing with any cases. So I'd just like to kind of finish with the last 5 slides now, if that's okay, and just talk through a couple of different kind of cases that we have been successful in, and hopefully it just gives you a flavour of the type of cases that we deal with. So my first ever negligent care case, and I was sceptical that we would be successful in this case, but my supervising partner knew better. So this was an elderly lady in a care home. She had suffered from Alzheimer's for many years and had a history of absconding from the care home, and she had actually managed to get out of the care home many times. She was on an observation chart, so staff had to record every half hour where she was within the care home. Within the care home, there was a door which had about, when you opened the door, there was about 20 concrete steps, and then at the bottom it led to a storage area that was used by staff. So on this particular day, the elderly lady went, staff found that they couldn't find her anywhere, so they searched the whole of the care home, couldn't find her. They contacted the police, a local search was done by the police, they still couldn't find her. Then they conducted a further search back of the care home, and they found her at the bottom of the stairs, in this cupboard area. And what had actually happened was that the lock on this door, it sometimes worked and sometimes didn't work. So a member of staff had been in to the cupboard to take down some stock of some kind, and the door hadn't locked properly. So the elderly lady was able to get in through the door. There was no light that came on when you go through. Unfortunately, the steps were quite close to the door, and she's fallen. And she, as I say, she was eventually found. She did survive for a couple of weeks, but then died of her kind of multiple injuries. We had received this case from another firm of solicitors who received a denial of liability. We intimated the case, and we received a denial of liability as well. But it wasn't until we did a summary application to the Procurator Fiscal, because there was an ongoing criminal trial, that we were able to prove that actually staff knew that the door didn't close properly all the time, but there was no proper procedures in place for checking the door or for reporting failures. So we were able to be successful in that case when we raised the case, and we managed to get awards for transmissible solatium and for the family. And in the criminal trial, the care home were actually fined $65,000 for the health and safety breaches. In this next case, this was an elderly gentleman 84, who'd been placed in a care home just for some respite care during COVID. He was a diabetic, and he'd had previous kind of pressure ulcers on his feet and everything. But when he was admitted to the care home, the podiatrist had confirmed that all his wounds had healed. The family didn't get to see him because of the COVID restrictions, but within 2 weeks of being in the care home, he was transferred to hospital with sepsis, where they found that he had a grade 4 pressure ulcer, and that's a pressure ulcer that extends right down to the bone. And he had multiple pressure ulcers. So he was admitted to hospital and he received treatment. He was ultimately moved into a care home because he did survive for 7 months. In this case, we did seek nurse and liability report from a tissue viability nurse who was able to say that the care home didn't follow procedures, they didn't reposition, the patient didn't use equipment for him, so we were able to go over the hurdle of fault and we were able to get the medical causation reports that we required. And we had to raise this case in the ASPIC. And the gentleman, he would have had like a life expectancy of another 6 months, but for this injury, according to our geriatrician. So we were able to get reasonable awards, £30,000 for transmissible salicium. We got £30,000 for his wife for loss of support, and £20,000 each for the children because the staff failed to follow the procedure. In this case, the next case, it's actually a case that occurred in a hospital. And as I say, the hospital cases are all about like clinical negligence. So the standard to prove fault is much higher. This was a 64-year-old gentleman who had significant underlying comorbidities, including diabetes, vascular disease, and he also received dialysis three times a week. He required to have a left above knee amputation, which he had, and the surgery was successful. He was then transferred to another hospital closer to home just for rehabilitation, but unfortunately became quite unwell, suffered a cardiac arrest. He was resuscitated, but he was transferred back to the original hospital to have an implantable defibrillator implanted. During his recovery, this was a gentleman who was used to weighing himself because of his dialysis, and one day on the ward he decided to he was in his wheelchair and decided to weigh himself, but the weighing scales in this hospital were different. They didn't have a ramp. There was quite a high step up. So they were quite different to where he was used to weighing himself. But he decided he would do this, and a member of staff did offer to assist him. He said, "No, it's fine, I'm used to doing this," and they let him do it. Unfortunately, as he sort of tipped his wheelchair, the wheelchair tipped back. He hit his head off the hard ground and he died of an intracranial hemorrhage within 24 hours. The family didn't realise that there was anything wrong. They just assumed that that their dad and their husband had been, it was his fault because he had done something. He tried to go on the scales perhaps when there were different scales and they shouldn't have done so. But then they received a significant adverse event report from the hospital which confirmed that there was failings by the hospital staff. And the failings were when the gentleman was in having his amputation, he ought to have been assessed. His wheelchair ought to have been assessed for the suitability at that stage, but it was never done. And had it been done, there anti-tip bars would have been fitted to the back of the wheelchair, and that would have prevented his wheelchair tipping back. So again, we did get an occupational therapy report in this as we had to raise the case because it's quite close to time bar. We also got a medical causation report, but unfortunately in this case, The gentleman's condition, his general health was so poor that he only had a life expectancy of a few months, but we were able to recover some transmissible solatium and funeral expenses at £6,000. We managed to get £35,000 for his wife, £5,000 for each of the siblings, and £7,500 for the children. So that was a good result for them. Just in this next case, this was an elderly 84-year-old lady who was unsteady on her feet. She had a history of confusion and was a high falls risk. And what happened in this case was that the lady was actually she was taken to the bathroom, but then she was left in the bathroom. But because of her confusion, she wouldn't know to call for a nurse. So she shouldn't have been left unattended in the bathroom. At first, the health board denied liability on the basis, that there was privacy issues, but we were able to get a report and it proved, that this lady, she shouldn't have been left in the bathroom, and sometimes, safety trumps privacy. She fractured her hip but died within a few days. And her life expectancy was 1.5 years, but we managed to settle this case, and we got £9,205 for transmissible solatium, and her children got just £19,250 each, and the siblings and grandchildren, again, they got £9,750. So it was a difficult case because of this issue about privacy, but we were able to be successful. And just the final case that I want to speak about is an 89-year-old lady who's was in a care home, and she was immobile and required to be hoisted for transfer purposes. The staff who were using the hoist, they didn't attach the sling loops to the hoist properly. They put the hoist up to quite a high height. It was 1.5 metres. And as they started the process, she fell from height and she landed partly on, you can see the legs of the hoist and the hard floor. And sadly, she suffered an intracranial bleed and died 12 days later. Again, we did get a medical causation report. Her life expectancy was 6 to 12 months. So we managed to get transmissible solatium of £17,000, which included some funeral expenses. We were able to get £15,000 for the sons, and there were quite a few family members who hadn't had any relationship with their gran for a number of years, we're talking 10 to 15 years, and we were able to get between £2,000 and £3,000 for each of them. So they were quite happy with that. So thank you so much for listening this morning. I'm happy to take any questions. Thank you.
Thank you, Joy. That was great. Really appreciate you taking the time this morning.